Hello, everybody. It's attorney Laura Sterling. Here I am live. Like I promised you all month, I was going to be here. Remember, we said we are going to do it a little early because I'm traveling the rest of the month. So I wanted to make sure that I got my live in, considering, what's going on with the world and everything. Anyway, I want to welcome you. You see my background? What does that mean? Yes, all month I've been pushing my fellow social workers. As you may or may not know, in my prior life, I'm a licensed clinical social worker. So that means I have my bachelor's degree in social work, my master's degree in social work, and then I got licensed here in the state of Florida. And then I decided to go to law school. So I had a very fruitful career as a social worker for many years. So I teach here at the university, and the first day of class, I always talk about what my background is. And I always refer to myself as 150 years old as I go through my experience as a social worker and then as a lawyer. So I kind of giggle. But I do want to take a moment because March is National Social Workers Month, where we kind of, just take a moment and appreciate those social workers that have impacted our lives. So I just want to do a shout out to my fellow social workers and say, kudos to you and God bless for everything that you do. It can be a difficult job and it can be a thankless job, but social workers do their job from the heart. That's why we become social workers, because we do it from our heart and we want to make sure that we're helping people and helping the less fortunate. And why I became a social worker, I think I just kind of tripped into it. I showed up at the School of Social Work at the university I was attending at the time. Let me do a shout out to the Huskies, St. Cloud State University in St. Cloud, Minnesota. And I like the people and I like the instructors. And so that was where my life led me as a social worker. And I mostly work in nursing homes. So I do know that a lot of times I go to visit nursing homes and I kind of miss it. I kind of see residents and the staff and I kind of miss it. I liked going in and knowing all the residents and saying, "Good morning, Mrs. Jones. Good morning, Mr. Smith," and kind of sharing in their lives. So anyway, enough about me. I want to send a shout out to all those social workers out there and let you know that we do appreciate you. Anyway, so I know you're kind of wondering and you're scratching your heads because I am back in Florida. You did have a video of me in Idaho and you saw the snow and the cold, and I had many layers. I am here in Orlando and I am kind of wearing a lot of layers. I'm wearing a long sleeve turtleneck, a sweater. I even have my Notre Dame blankie on my lap. I'm just a little chilly. It's just a little cool here today, okay? I think it was like in the upper 40s to lower 50s today when I woke up, and I just haven't gotten rid of the chill yet. And now it's in the 60s. I know y'all are like, really? We don't have any sympathy for you, Laura. I know, but I'm a little chilly. So probably by the time we're done, I'm going to be sweating and be stripping off these things. But in the meantime, I'm all cozy. I consider myself, a little a chill bug because I'm always kind of chilly. Anyway, so don't giggle at me and don't laugh at me. Anyway, again, I want to welcome you to my live. My live, as we've been talking about all month, is going to be about the high profile case that's been in the media, right? There's two of them right now. One just finished and one has is very, very, very early in its stages. So, what are we talking about? So, today I just wanted to talk about those cases. Now, they're both criminal cases, they're both high-profile criminal cases, and they both involve, murders of people, and I know that may be difficult for some people to talk about or to hear. As an attorney, I've done murder cases, I've done, as far as murder cases and as small as a no valid driver's license. And as an attorney, we look at it under the United States Constitution that everybody is entitled to representation, to fair representation, to full and fair representation in court, no matter what's happened. And so I truly believe that no matter what the history, no matter what happened, everybody is entitled to an attorney and everybody is entitled to have their day in court if they so choose. Now, some people can choose to just take a plea offer, plea out so they know for sure what's going to happen in their case. When you go to trial, you're leaving it in the hands in a criminal case with a jury. I'm going to take some water because it is kind of dry in here because I have the heat on. But when you go to trial, you're putting your future into the hands of either 6 or 12 people that have no idea who you are, have no feelings towards you, have no affiliation with you. Their job is strictly to follow the law. That's what they're given. So I always tell my clients, if you want to go to trial, I don't have a problem. I'll take you to trial all day, but understand you're putting your life in the hands of these people that you don't know. And so sometimes it's easier for you because you know what's going to happen when you do that plea. You know, maybe the plea offer is 3 years in DOC, we call it Department of Corrections, which would be prison. So you know you're going to spend 3 years, or you know you're just going to be on probation, or whatever it is, you know what the outcome is. You go to trial, you know what the worst case scenario, you know what the worst case is that the judge can give you. Much like in this case that just finished, where he got, I think it was life for them. So now life is life. So here in the state of Florida, and it's different throughout the United States, here in the state of Florida, when you are given a life sentence, it is life. We don't have parole. We don't have early release for good behavior. We don't have any of that. When you're sentenced to life, you will spend the rest of your life in prison until your life ends. And that's when you get out of prison. So I always try to tell people, if we're looking at a life sentence, I haven't had that yet, but if I was, I'd tell them, remind them life is life in the state of Florida. Anyway, so I wanted to bring this and kind of talk about it and get it out there. And if you have any questions, please feel free, put them up in the chat. I'm more than happy to answer them if I can, understanding these two cases are not within the state of Florida. So I may reference some Florida laws. I don't know the laws in these states. I'm just going strictly off of what the media. And also know that, everybody has their own opinions about these cases. And even the cases we had here in Florida, for example, the Casey Anthony case, we all had our opinion about it, but she had fair and full representation, and they did a good job representing her, and so she was found not guilty. Whatever you feel about that is fine. Just understand she had her day in court. And then the George Zimmerman, same thing. So those were some high profile cases that were here in Florida. So here we go. So I hope you're settled in. I hope you have your little, whatever you're going to drink today, water, soda, tea, coffee. I didn't have my tea this morning, so I'm not as chipper as I usually am. But whatever you have, if you have a little snack, have your little pen, piece of paper, whatever you're going to do, and get ready to type if you want to send me a question. Today's subject, the Alec Murdaugh case. Yes, that's been on. I tried to watch it as much as I could. I tried, but I'm working. I can't really watch it full time. I wish I could. I would like to one day. I think it would be fun to be a news commentator. So I just spend all my days watching these high profile trials, criminal trials, which really interest me. I have this warped kind of sense of interest where I really get interested in these criminal trials, these high profile criminal trials. It just really interests me about how they run, how they work, how the justice system works, how the police do it. So anyway, Richard Murdaugh. It's actually Richard Alec Murdaugh, but he was known as Alec, right? And we all know the story. The Murdaughs were very prominent in South Carolina. They were, in fact, the county where they were at was more or less called the Murdaugh County, right? And what it is Alec, who's, let's say he's here. I mean, his kids are underneath him. So, but Alec is here. His father, Randolph Buster Murdaugh Jr., he was a district attorney. Oh, I'm sorry, Randolph Murdaugh the third. That was Alex's father. He practiced there as well. Then above him was Randolph Buster Murdaugh, who was Alex's grandfather, who was a district attorney in that county. Then was Alex's, what was it? His grandfather, great grandfather, Randolph Murdaugh Sr., who became the district attorney in 1940 and then founded their family law firm, which Alex was a part of. But now that all this has happened, he resigned from that, and they've renamed the law firm to no longer have his name in it. So it's a whole new law firm with a whole new name because they didn't want to be associated with him, which is kind of sad because the family has really been prominent throughout that county, and it's really been kind of the legal, what do I want to say, the legal stay throughout that county. I mean, if you're getting a county that's named after you, Murdaugh County, I mean, not technically, but how everybody was calling that, it obviously means that you had a lot of say in that county. So that was kind of how it went. It went from, you know, it ended with Alex, with his father, with his grandfather, with his great grandfather, where it started. And that's a lot. I know a lot of law firms around here that are the same. There's one in Apopka, same thing. Started the family, just keeps going down. Very good law firm. So, anyway, that's kind of the background of where they came from. Now, there seems to be a lot of controversy, and I don't know if you've watched the Netflix documentary or any of the Dateline 2020s about the Murdaughs and Alex and his family, his children, and about the things that have kind of happened over the years that are now being reopened and reinvestigated. For example, all of these deaths that have happened in relation to the Murdaughs, which have now been reopened because of this investigation or because of this crime and this trial. For example, you keep reading in the news now because Alex's son, his one surviving son, Buster, now there's some controversy about this death of Stephen Smith, which happened in 2015. He was a 19-year-old that was found dead from blunt force trauma, and they ruled it as a hit and run. Well, now they're questioning that. Okay, really? Was it a hit and run or was it not? So they've reopened that investigation. Also, the housekeeper and the caretaker of the children of Paul and Buster, how she fell at the home. It was alleged she fell on the back stairs, that she fell because they had all these dogs and she got tangled up. And she ended up passing away a few days later because of that fall. And so now that's being reopened to say, well, what really happened here? Was it really a fall? What happened? And also how Alec told the children and told the family, hey, I'll do this, against my insurance, my homeowner's insurance, and I'll split the proceeds or I'll give you the proceeds. And they saw none. But Alec got, what was it, like 4.3 million or something like that he got from it, but the family got nothing. So they're again reopening that investigation. Then we've got the Mallory Beach. That was Paul. Paul was charged with 3 felonies following her death from a boat accident. He was allegedly driving the boat and it ran into a bridge and she was flung off. God bless her. And she wasn't found until the next day and she is deceased. And so that was kind of still going on. Now that Paul has passed away, or Paul was murdered by his father, allegedly by his father, or he was found guilty by for murdering him, that criminal case unfortunately can't go forward because they don't have a defendant. However, there is a civil lawsuit, and so the attorneys for her are asking that Murdaugh hand over his financials, or that who's ever in charge of his financials not hand them over so they can see what's there. So that case. Then after the murders, how Alec concocted this thing allegedly to have this assisted suicide or something. I'm not really sure. He claims that he was shot, but claimed it was later, and it was a suicide attempt so that Buster could get some money, but it was all convoluted. So, they're trying to map that out to see what's going on. And then finally, nothing to do with the deaths, but the embezzlement. The embezzlement that Alex Murdaugh admitted to on the stand, where he admitted taking money from clients, having this whole scheme. He involved this gentleman called Lafette from a bank to help him. And of course, on the stand, he said that gentleman had nothing to do with it. So now that gentleman's attorneys are now filing something to get him a new trial or to get him released because Murdaugh is saying he had nothing to do with it. So it's really going to be up to the court on that. But they claim that he took from like 30 to 50 people and could be as high as 20 million. So, I mean, there's just all of that. And we'll kind of talk about that embezzlement or those financial crimes later on because it did become an important part of the trial. So, I see. Hi, William. How are you? I'm glad you could join us. I see you have a question. What about Paul Murdaugh killing Mallory Beach with his boat? Could that be a clue of a third person taking part on the murders as a revenge? Hmm, as a revenge. Oh, I see. For the Mallory Beach. What a thought process. Everybody has their own opinions about everything, but that's quite a thought process, William. Um, that maybe could have been something that they used as reasonable doubt because understanding that all the all the defense has to show is some reasonable doubt, and they tried to do that during the trial, didn't they? By saying, well, one person couldn't have done this. I mean, there's no way that one person could have done this. So they're creating that reasonable doubt of there must have been another person or there must have been a couple people. So just raising that doubt, and that would have been a good potentially raising of doubt saying, hey, wait a minute, these deaths that kind of follow him, and follow Paul or follow the family. Maybe it was somebody for revenge or something, but very good thought process. I like that, William. Good thought. You're thinking like a lawyer. Good for you. Anyway, so very good question. So, anyway, okay, so we talk about the trial. So, what were the big points in the trial? What was the big thing that kind of got um, Alex? One thing, they interviewed the jurors afterwards. I don't know if you saw that. They interviewed one, then they had three that they interviewed. And they really said it was what? The video, right? The video. Paul was talking from the grave. You know, my son, he's 24 years old, right? Let me tell you, I'm always put the phone down, put the phone down. We're at dinner, put the phone down. Can you talk to me? Put the phone down. Can you put the phone down? But this was a time when Paul had his phone and was shooting for whatever reason. He was videotaping these kennel. I don't know why he was, but it was so poignant for him because that really showed, you know, that Alec was there, that his father was there minutes before the killing because the medical examiner said the killing had to happen around 9 but anywhere between 8 and 10. And so when Alec took the stand, that's why the state really honed in and really drilled that issue home was the time frame. And so, I did watch a little part of that and I was like, man, that state, all the timelines, and you saw on the boards, and the state was down showing the boards and everything, and it kind of got irritating. Like, gosh, this is irritating, but it really hit it home. It said, "This is the time frame that you're saying, correct?" And he said, "Yes, yes." They really pinned him down to a time frame. And so that hurt him because then how do you wiggle out of a time frame? You can't wiggle out. You were there. You were at the kennel for whatever reason you're trying to say you were at the kennel, but you were there. And why, when you went back, when you allegedly went back to see them and they were deceased, wouldn't that be the first thing that you would say to the police? I was there. This is what I saw. This is what I didn't see. That's your son and your wife. Wouldn't that be the first thing you would say? Listen, I saw everything was fine. It didn't seem like anything was wrong. Or, it seemed that there was a third person, there was somebody there, a friend or anything, but nothing was said until it came out in court. In fact, in the state of Florida, like I'm assuming it is with most states, because it was filed here, the defense filed what we call a notice of alibi. A notice of alibi is saying there is no way I could have committed this crime because I was with so and so. Like he said, I went to see my mother, I went to see my father, whatever he said. I was with them. So there was no way in that time frame that I could have done this because I was with them. And state, you can go talk to them, you can go have a conversation with them. You're opening that door. He filed that in November of 2022. That's when he filed it. And then all of a sudden, the trial in February. Oh, I was there. Wait a minute. Yeah, wait a minute. What do you mean you were there? Why didn't you tell anybody? Well, I was paranoid. Listen, I understand, he says he's got this drug addiction, whatever it is. I get it. You're paranoid, you're this, you're that. But this is your family. So you would say where you were. So, oh, I see we're just flopping up questions and let me get. And like I said, I may not be able to answer your question 100%, but let me get to it. Michael, hi, Michael. How are you? Is it true that Murdaugh changed his clothes on the night of the killings? Can that be traced? Oh, yeah, they have, because they have the picture, right? They have him sitting, I think, in the police car, because the first responders, the three officers that showed up first, he was in the car and he had the t-shirt and the shorts and, he's telling them about it. And then later on, he had the polo shirt, he had changed his clothes. And then when he went in to get interviewed, if you saw that video, he was wearing the polo shirt and the khaki pants. You saw that? So he did change his clothes several times. So yes, I don't know if they took his clothing or not. I would think that that would be something that they would do to see if there's any trace of anything. I never heard that in the trial, if that ever came out about, I know they talked about his change of clothes. I don't know if they ever grabbed them and were able to, look at them and see if there's anything on there. There may have been nothing. It just really depends. Sometimes your clothing is doesn't always pick up everything. So good question. Way to pay attention too. That was something that was really pointed out. Then I have hello, is it Oh, it's a beautiful name. Gracia. That's a beautiful name. Hi, Laura. Lovely background. Thank you. Thank you. Put a shout out to our social workers when you see one. So make sure. I have a question to you. I've read he deleted 5 calls to Maggie from his cell phone. Isn't that suspicious? I don't know if he did that or not. If he did that, that would be interesting. And it would depend on the time frame of when he deleted those phone calls. It would seem, I know he was trying to attempting to try to bolster his alibi by calling and texting and see, I'm trying to get a hold of them. I'm trying to get a hold of them. I don't know what's going on. I don't putting those calls out there. I don't know if he got calls and he deleted them. It would seem, if she called him, that might bolster his claim of not having responsibility. So I don't really know. But yeah, deleting things and getting rid of things is always kind of suspicious when you see people. I can't remember what movie it was, one with Tom Cruise, The Firm, and they're in that he stumbles into a room, conference room, and they're shredding just that's a little suspicious. So when things are deleted or destroyed, yes, that can lead to great suspicion. So good observation. Then I have Paula. Hello. Hi. Just saying hi. Great. Good to see you. I'm glad you're with us. So I'm glad to see you are. Remember, if you have questions, just let me know. But I'm always anxious to see you guys and happy to see you. So anyway, so with Mr. Murdaugh. So again, they Murdaugh, he was really trying to cover himself. He was speaking to several people. He was trying to call people. He was really trying to cover himself. Now, that property is a very large property. If you see it from up above, it's very large. From the home to the kennel, it's quite a distance. But he had what did he have? The little golf cart. Um, and I know that they were able to recover shell casings that were related. I think that they were able to connect one of the shell casings to actually Paul's favorite gun. There was 2 different rifles that were used, which is again, having to use one gun rifle. And I grew up in northern Minnesota, so I was, I hunted with my brothers hunted, so we used rifles as well. But they're not an easy thing to use. You have to use a lot of power and you have to have strength and be able to load and all of that kind of stuff. So anyway, so they said that 2 different rifles were used. Murdaugh did actually leave the premises and he went to his mother's place, and he was cutting all the times, making sure that he had the times and he knew exactly the times, but yet he still didn't give that to the police. And it just kind of, in my opinion, again, it's my opinion, it just seems suspicious that you remember it so much now, which is what, 2 years later, 2, 3 years later, which, as you know, I mean, I have trouble remembering what I did yesterday morning, let alone, what I did today. So, it's just funny that now he was able to, okay, pin down the times and pin down when he didn't even mention it to the police. And then as the subsequent, what do I wanna say? The subsequent investigation went on that he didn't even provide that information. Maybe when he said he went to rehab, got off drugs and everything. Well, then you're no longer suspicious and bring it forward. This could help your son and your wife and find who did it if you felt, if you were trying to claim that you were so innocent. But anyway, but they said that the jurors really said that it was the video, it was Paul talking to us from the grave. It was him getting on the stand and lying about it. They talked about those, and I'm going to talk about those financial crimes for a minute. They said the financial crimes really didn't play into it. It did, they said it did show that, he knows how to lie and he knows how to be deceitful, but it really didn't play much into it. It was really the video and the fact that he lied about being there, and why would he lie about being there? One issue with those financial crimes that I could foresee being an appealable issue, because his attorneys have already filed a notice of appeal. Now, let me tell you how notice of appeal works here in Florida. We file a notice of appeal after, a trial, after sentencing, to appeal it. You have so much time to do it. You only have a certain amount of time to do it. So you got to get that, as long as you get that notice of appeal in, you've locked that time. So that notice of appeal, you don't necessarily have to be specific. You don't have to cite case law. You don't have to do this. That comes later when you do your appellate brief. In your appellate brief is where you're going to have, these are the issues that need to be appealed. Now, you could name those issues that need to be appealed in your notice of appeal, but you can be very generic and all of that. You're not going to get into this whole argument in your notice of appeal. Your notice of appeal is to lock that appeal in. So I'm assuming when they do their appellate brief, which I don't know what the criteria is in their state. Here in Florida, we've got a certain amount of pages. The the appellate court here in Florida is very specific. They want a certain number of pages, they want it paginate, they want all these things, and that's what they want. And so you're really limited. So you can't go off and be, as you can tell, I'm kind of a wordy individual. Even when I write things, I tend to be a little wordy. So I really have to hone myself down when I've done an appellate brief in the past, because they don't want to hear all of that. They want the facts. They want the facts, just the facts. That's it. So I have a feeling, though, one of the issues in their appellate brief is going to be those financial crimes. The judge did allow that the financial crimes come into play, that they kind of show a motive, for lack of a better word, that why the state tried to do that connection of, he did these murders to take away attention from what he was facing with these financial crimes. So all of those financial crimes, everything was able to come in just like a floodgate. So that may be an appealable issue. I don't know what the argument was, and I know why the judge let it in by just what I said, that they're trying to use it as a motive, but that could be an appealable issue, that maybe if the appellate court feels that it was prejudicial to him and the outcome would have been different um had those financial crimes been let out, potentially there could be some kind of ruling and some kind of return to the trial court. But we don't know that. This is all speculation, but I have a feeling that's one of the things that I know I would. That would be one thing that I would do an appeal on, was letting those financial crimes in, because what I would feel, again, my opinion, is that that could prejudice the jury. Just because I lie on one thing doesn't necessarily mean I lie on another. So that could be an appealable issue for them. So Um, but anyway, but again, the jury didn't really, use that. They said that really wasn't much. They just said that the video came out, he was there, it was obvious he was there. Everybody said that was his voice, and then he finally admitted, he got on the stand and admitted he was there, and really didn't give a good reason why he didn't tell when that's his family. So, he really had no choice but to confess from it. So, like I said, they just said it was Paul speaking from the grave, and they wanted to know why did he lie? Why didn't he just tell anybody about it, rather than doing all of this, filing notices of alibi and all that kind of stuff. So, it just they said it just didn't look good to him, and they said he was very evasive towards the state questions. He is a litigator. He is litigator. He is an attorney. And sometimes as attorneys, we feel, yeah, we can do this. We can do this. But boy, getting on that stand, even as a non-attorney, you feel, oh yeah, I got this. I got this, right? I can do it. I need to tell them. I can keep my composure. And let me tell you what I tell my clients. You have a right not to testify. And this is a soliloquy I give my clients. And then the judge also has to ask the client if they want to testify or not. But I always go over it before and say, you have the right not to testify. The jury cannot hold it against you if you don't testify. They cannot say, oh, well, he must be guilty because he's not getting up there to talk. So they can hold it against you. And the judge will tell them that they can hold it against you if you don't get up and testify. It's your choice if you want to testify. My advice is that you don't get on that stand, because if I'm questioning you, because I'm going to be the first one to question you, and I will treat you like a baby. I'll ask you the easy questions. It'll make you look like you're so innocent, you're so perfect, and you would have never done this, and all of that. I can do all of that. But then when I sit down, and now the state is getting up to question you, I can only control that so much. I can object, and I can object. Some of my objections will be sustained, meaning, yay, victory. They don't have to answer the question. Some of them will be overruled, and you have to answer the question. So I can only control so much. And I can't control my client's temper on the stand. I can't be like, hey, 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 cool it down, cool it down. I actually had a case one time. It was a child sex case, and our client, no, he wanted to take the stand. He wanted to take the stand. After we told him, hey, it's not a good idea, after the judge informed him he had every right to remain silent, he said, nope, I want to get on the stand. We questioned him, treated him, kid gloves. It was beautiful. It was perfect. I always try to, as well, bring out the bad stuff to kind of soften the blow so that the jury doesn't hear it first from the state. So I try to think of, okay, this is what the state's going to ask. So I try to soften the blow by asking it a nicer way and an easier way. So my client kind of has control. So we did fine. We sat down. We were done. We were done presenting our direct. The state gets up to do a cross examination. 5 minutes he lasted on the stand before he lost it. And all she was really asking him was, where did he live? I, I don't know. For some reason, he didn't want to give that information. He didn't want to give it. And she kept asking, well, where do you live? Well, why don't you want to tell me? And he blew up. I don't have to tell you anything. And this is exactly what the state did. No more questions, Your Honor. Because he just showed his personality, and the jury kind of, wow. Now they can't use that against him as far as, oh, he's guilty because look at, he's crabby, or he's yelling, or he's out of control. But they can say, wow, okay, he's not even answering a question directly just about where he lives. I mean, what's going on here? So I always try to forewarn my clients before they want to take the stand because I can only control so much. So I'm sure that his attorneys had that conversation with him. I'm sure he knows that conversation. He's a litigator. He was a litigator before he lost his bar license. He was a litigator. So he knew, I know as a litigator that that's, what would happen. So, but, being a litigator, being an attorney, sometimes we have in the back of our head, hey, he's done it for many years. His father, his grandfather, his great grandfather. So he's lived it and breathed it. And the judge said he was a good litigator. He was a good attorney. He could go into court and take control. So he probably felt I can take control of this. But, that doesn't always work. And even the jury said he was pretend crying. There were no tears. We didn't see any tears. So, he was putting himself in a position. But anyway, so let's say, they do these appeals, the financial crimes. Let's say that the appeal doesn't work. The appeal is denied. He's done all his appeals, to the district, like we have here in Orlando, we go to the fifth DCA District Court of Appeals. Let's say they deny and if they don't proclaim affirm it, just meaning they affirm and there's nothing more that you can do, or they send it back or whatever, and you can appeal it to the Florida Supreme Court. Let's say he exhausts all that. I'm assuming in the state where he's at, as we do here in Florida, we have something called a 3.850. And that is where we say ineffective assistance of counsel. I'm sure they have that there as well as we do have here. I mean, every state has that. You know, 3.850 says, and if here in Florida says ineffective assistance of counsel, that according to Strickland v. Washington, which is a United States Supreme Court case, that counsel must be effective and ensure fair and procedures are done in a trial and you're given a fair trial. And if that attorney doesn't fit that criteria, then you can potentially get, now there's a two-pronged test. The lawyer's performance was defective and contrary to errors so serious that it did not provide adequate representation. So that's the first prong that you have to prove. The second prong is that it prejudiced the defense. If that had not been done, if the attorney had not been ineffective, the end result would not have been what it was. So that's always the end. That's the very last thing, is to claim ineffective assistance of counsel. And generally what they do is the person, or they hire an attorney and they file a brief with the court saying ineffective assistance, this is why. And it's usually very lengthy because you have to go into detail as to why they were ineffective. Here in Florida, it goes in front of the judge. The judge decides whether to have a full-on evidentiary hearing. Now, I've done them before, and I think the last one I did, I think my client had, because they often do them on their own. I think there were 5 points that he brought up, and the judge only granted it on 2. Only granted it on 2 points, denied the other 3, but wanted to have an evidentiary hearing on 2 points. So, we prepared for these 2 points. That's all I could do. That was just all I could have the hearing on. So we have the hearing. I call the attorney. I maybe call witness, whoever I need to call to get on that stand to prove my ineffective assistance of counsel. So let's say the judge does say, okay, Murdaugh, yeah, they have this hearing. Supposed they have the same thing in that state. And the judge says, you're right, your attorneys were ineffective. However, the judge can also say, but it didn't affect the outcome of the case. It would not have affected the outcome of your case. Your case would have ended the same way. Or they say, you're absolutely right. This was a huge miscarriage. And so we're vacating, sending it back down and redoing it. In fact, I was just watching Court Cam. I know. See, I do love watching those things. And it was a woman that I think that she was drunk and she had driven over an embankment and killed a family in their car below. She survived, but they didn't. She was found vehicular homicide. She was sentenced, I think, let's say 18 years or whatever. She appealed it and actually did ineffective assistance of counsel. And the court ruled in her favor and vacated that. And now she either has to go back to trial or the state can come and say, listen, we don't want to go through a whole trial. Here's an offer. Do you want to take it rather than going back to trial? So, that may be something down the road that Murdaugh may do if he is unsuccessful with his rest of his pleas. So, anyway, right now he's sitting. Yeah, I don't know if he's here in Florida. We have a receiving facility. When you've been sentenced to DLC, Department of Corrections, you go to a receiving facility. And you notice Murdaugh, they shaved his head. I told my mother, I said, they're going to shave his head because they always do that. Sure enough, his hair was shaved off. They hold him there until they find a bed. Could be anywhere. He can't say, listen, I would like to be close to my son Buster so he can visit me. No, no, they're going to put you wherever there's a bed. So he will be sent wherever there's a bed. Now, if he has an appeal and it's sent back, then he's going to be brought back to the county for that. Or he's going to, if he does an effective, it's going to be the same thing. So anyway, so we'll see what happens with that. The story continues, but I do want to take a moment, as I really want to take a moment to remember the two victims in this case, which is Paul and Maggie, his wife. I mean, unfortunately, they are the victims, and sometimes they're kind of forgotten, but we do want to remember them. Um, as I talk about this. So the last case I want to talk about is the Moscow, Idaho murders. Um, Now, I'm not going to say much about this because it's very early, very, very, very early. And I know a lot of you are wondering, what's going on? It doesn't seem like anything's going on with this case. And you know what? You're exactly right. Because what's going on in Idaho, and it's funny that I was just in Idaho. I thought about that. I go, oh, look, I'm in Idaho. And Idaho's a beautiful state. Um, but what they're doing is a preliminary hearing. You may ask, what's a preliminary hearing? A preliminary hearing in that state is saying, hey, are we going to go forward with these charges? Is there enough evidence to go forward with these charges against Mr. Koberger, Brian Koberger? Is there enough evidence? And so what they do is they have a preliminary hearing. It's almost like a mini trial where the defense presents whatever they want to present, the state presents whatever they want to present, and then the judge decides whether or not there's probable cause to move forward to a trial, to continue on with the case, or say, you know what, state, you're just shooting the breeze here. You're nowhere near having these charges go forward. Or say, yes, I'm finding that there's probable cause to move forward. And then it just progresses on, and the defense gets an opportunity to, file any pretrial motion, whatever they're doing, they're going to do depositions, all that kind of stuff. So usually in that state, and I did look up that state, I think what they said is it's usually within 14 days. And it is, let me see here, it's held in front of a magistrate, but I don't know. I think it might be held in front of a judge here, but it's held without a jury and it's within days of the arraignment. Now, those of you who have followed me, an arraignment is generally the first step. Well, besides first appearance, if you're in custody, first appearance is really to say, okay, this is what, the affidavit says, probable cause of what you're being charged with, if you're entitled to bail, whatever, bond, all that. And then an arraignment is kind of just like a formal saying, okay, these are the charges you're being charged with. Sometimes the state will give an offer at an arraignment. Sometimes they don't. What I usually do, I just waive appearance because, yep, I know what's going on. I need to get the discovery or the evidence in this case. Here they're asking for a preliminary hearing. It's held without a jury. So there's no like deliberations or jury selection. Oh my gosh, that would take forever. It's just the judge trying to find sufficient evidence to see if the defendant should go forward with the case or if the case should be dismissed. So that's kind of where we're at. And the defense asked for extra time, obviously. They weren't ready. There's so much. I mean, these were the murders of 4 college students. I mean, there's a lot going on, and there's a lot we don't know about because there's a gag order. Now, you may ask what a gag order is. A gag order is the court saying nobody's to talk about this. the defense, because a lot of times you'll see defense attorneys on the Today Show or Good Morning America talking about the case and trying to get out ahead of everything. Nope, nobody can talk. Nobody can talk. And so it's kind of put us at, gee, what's going on? We don't get to really know. Now they're releasing things here and there, like, the warrants, what they found in the warrants, and, that they found DNA and all of that kind of stuff. And just, the video of how his cell phone was tinging and all of that kind of stuff. So obviously with the gag order, the media, of course, file something with the court because they feel constitutional, right to free press, all of that, to get that information. The the public has a right to know, but the court, and I don't know what's been ruled on their motion to get this set aside, but the court has to look at it constitutionally. Okay, are the rights of the free press, does it override, the prejudicial value it will have on releasing this information to the defendant? So that's what the court has to kind of weigh. So, hi, William. Oh, you're back, William. Is there a solid motive yet for the Moscow murders? I don't think so. And again, there's a gag order. So there may be, and we just don't know about it. I have my suspicions, but we don't know. There's a gag order, so we don't know. I mean, I'm thinking that will eventually potentially come out at one point or another. Um, but at this point, we don't know. So it's just suspicion. So I'm sure, William, you have your suspicions. I have mine. I'm sure everybody else has theirs as well. I mean, God bless these little students. It was Kaylee, Madison, Xana, and Ethan. I want to make sure and say their names to give them respect and to, really remember them and cherish them at this time. So and really, feel for them. And the more information that comes out, it's just a really sad situation. So sometimes we think that the justice system moves so slowly and it seems to just, drag on. And, these family members, I'm sure they're like, come on. They want that. They want that closure. They want that satisfaction. But things move slowly sometimes because everybody has a right to a fair and just trial and fair and just representation. And so as an attorney, that's our job, to make sure that our client gets that, and then our client gets the best representation that they can. So I still try to remember the victims in my cases and really give them respect and, um, give them room to grieve. My murder case that I had, I remember there were victim impact statements, and I kind of stood next to my client. He was sitting because he was in custody, and I just kind of put my hand on him, like, let them talk, let them have their time. Don't interrupt, don't say anything, don't do anything. This is their time. And then my client spoke as well to the court, to give him his time as well. So he's entitled to that as well. So but anyway, so those are kind of the high profile cases that we have, that they're not in Florida. We have some of our own little ditties going on here that aren't as big as this, are a little smaller than this, but that I'm also watching. So maybe down the road, I'll be able to do some lives and kind of tell you about those cases. The big thing that we have now that gets us all so involved with these cases and gets us so into these cases is social media, right? I mean, when I was growing up and stuff, I mean, even when did social media first come out really big? I think maybe, within the last few years, and being able to watch all these, like the Casey Anthony, and just being able to watch them and see them and see how the judicial system works. And we didn't have that when I was growing up. I remember the first televised trial that I watched was the O.J. Simpson trial. That was how long ago? That kind of dates me, doesn't it? But being able to watch that and see how it works and to see how the judicial system works and whether it's broken or it's flawed or whatever it is. But that was our first kind of taste of it. Now, some of you may not remember because you may have been very young. Me, I'm old as they come. So I was able to watch that and kind of get involved in that. So and see how that worked. And that really kind of piqued my interest as, oh, this is kind of interesting. And we can watch these kind of things because before it was just bits and pieces, whatever you got on the evening news, right? You didn't get all that, or whatever you got on a um, I remember Dateline or 2020, whatever it was, that I would watch bits and pieces of it to get it. But now we're in such an age of social media and everything that we're able to kind of see what's going on and gather our own opinion, which is great because society, that's how we're able to do things, is have that free will and have that ability to form our own opinions and have our opinions and voice our opinions how we feel fit. So again, thank you so much for joining me today. I'm so glad that I hope that, you found some entertainment from this. It was really just kind of giving you a little snippet of what went on with these two cases. And hopefully down the road, maybe I'll be able to talk more about the Idaho murders, maybe after the preliminary hearing, to kind of talk about what happened there and what they had, because that's when it's going to come out. That's what's going to come out, what they have, their witnesses, all of that kind of stuff. So I don't know if it'll be televised or not. That's going to be up to the judge whether or not he wants it to be televised. It's his courtroom, his or her courtroom. So whatever they decide, it's up to them. But hopefully we'll be able to talk again about that. But remember, if you have any questions whatsoever, if you just want to shoot me an email or shoot me something on social media to ask me about, hey, I'll be more than happy if I can answer it and be here for you. And if you ever come across where you've ever been charged with a crime and you don't know what to do and you're scared and all of that, give our office a call. As long as you live in Florida, give our office a call and we'd be more than happy to help you, hold your hand through it, help you get through it, and do the best that we can and do that full and fair and just representation of all of our clients. So thank you so much for joining me, and I'll see you again next month. Have a great day.